Good evening, everyone. As Stephanie mentioned, my name is Laura Brown, and I am the Executive Director of something called the Tennessee Alliance for Legal Services, which is an organization based in Nashville, Tennessee. We are not legal aid, and we're going to kind of talk through that just a bit as we go throughout this presentation. And as Stephanie said, you are welcome to enter questions in the chat. I will try to monitor that as well as I can. I have two screens set up, so sometimes I don't always catch chat, but I know that Stephanie will. And then also, you're welcome just to ask questions as we go along. I know it's later in the evening. For those of you on Eastern time, it's after 7 o'clock. And I understand that. So if you have questions at any point in time, just go ahead and stop me and we'll talk through them. And if I don't know the answer, we will get you an answer. So as I mentioned, let's see if I can, there we go. Before we get started, I do have to do this little disclaimer, of course, right? At the beginning of all the presentations that I do, because I am an attorney by training, and I am licensed to practice law here in the state of Tennessee, even though I do run a nonprofit, so I get to support other people every day as they provide direct legal services to folks. And I get to meet with people like you guys and do presentations, which makes me very, very happy. But I do have to do this little disclaimer that just states that everything we're going to talk about today is for educational purposes only, and it's not legal advice. If you have specific questions about specific situations, I would please encourage you to speak to a licensed Tennessee attorney. I know that I am, and I have been set up appointments with folks to talk about specific legal issues after the presentations. And we've talked through some things, and I'm certainly happy to do that with you guys too. If we have specific questions or things that, we need to talk about offline that might have, some details that you might not want to share with everyone, and we need to worry about attorney-client privilege and that kind of stuff. So happy to do that, but I do, like I said, have to give that little disclaimer before we get started. So I want to briefly introduce the organization that I work for, and it's Tennessee Alliance for Legal Services, and you'll always see us abbreviated as TALS because we have the longest name, unfortunately, in the history of ever. And our mission, though, is to strengthen the delivery of civil legal help to vulnerable Tennesseans. And how we do that is through a number of different ways. We are not legal aid, and we're going to talk about the legal aid organizations in this presentation, but we're not legal aid. We were founded in 1977 as the organization to support the legal aids. In the 70s and 80s, a lot of changes were coming around with the way that legal organizations could use something called Legal Services Corporation, or LSC funding. Organizations that receive LSC funding are traditionally what one thinks of when one thinks of legal aid organizations that provide, that do income testing, check where someone's income is, and then provide free civil legal services. Those legal aids could no longer represent immigrants. They could no longer have any involvement with justice-involved individuals or incarcerated individuals. They could no longer do class actions. They could no longer provide a lot of education outreach and even some advocacy on the legislative level. So every state formed a TALS as a state support agency. There were only about 6 to 9 of us left across the United States, believe it or not, that have survived over the years. And TALS does, like I said, we operate statewide and we provide direct legal services, and we're going to talk about those. And then I do a lot of work, and my staff do a lot of work to support the legal aids throughout the state. And we have 4 of them, and we'll talk about them in a second. The topic of our conversation this afternoon is talking about some of the legal issues and questions that arise as we age, right? And we're going to do like a 30,000 foot overview and talk about some of the most common issues that arise and the most common questions that I get as I go throughout the state and do presentations like this. And as I said, the focus is issues that tend to arise after we turn 60, but all of the information we're going to talk about today is very applicable to anyone, no matter their age. As long as they're over 18, everybody should have a will and have a power of attorney, and we're going to kind of talk about those things as well. And one of our goals tonight is to provide information on resources that exist as well. So you'll come away with some information and also some resources. And I'm happy to share this presentation with Stephanie, and she's welcome to email it out to you guys if you're interested in any of, having a hard copy of any of the information. That's not a problem at all. Just briefly about me, as I mentioned, I am an attorney, and I worked for the first 5 to 6 years of my career as a litigator. And I was in court all the time. We did very lengthy trials. 2-week trials were not uncommon. Then I had a little one and decided that 100 hours a week was no longer going to work for me. So then I moved over to doing some part-time legal work, and then moved over into the nonprofit and government sectors. I've been general counsel for the Tennessee Commission on Aging and Disability for a number of years. So I have worked with the Tennessee population age 16 over for a number of years, and that is my passion population, and the population that I'm really excited that I get to serve now on a statewide level at Tennessee Alliance for Legal Services. While at TALS, we serve all ages. We do have a senior legal helpline and do lots of folks. I was just in Memphis yesterday. Sorry, my days are getting mixed up. At a senior center doing a clinic with one of the legal aides on some documents. So very invested in helping all Tennesseans get the access to legal services that they need, but particularly those age 60 and over. All right. So the first thing that comes up as I go across the state or as I talk to folks is, do we need a will? And I always tell folks the answer to that question is absolutely. I always recommend that folks have a will. Now, we're going to talk about a package of documents that I recommend that everyone have. The first one that we're going to talk about is that will. And the will, in the most simple and basic of terms, is a document that tells everyone what you want done with your stuff right after you're no longer here on this earth to decide what happens to your things. And the benefit of a will, and the benefit for all of the documents we're going to talk about, a will, powers of attorney, and an advanced care plan, the benefit of all of these documents is that you can set out your wishes and you can tell everybody what you want done relating to your health care, or with a will relating to your things. Always important to have one. If you don't have a will, it is not a complete barrier for people to inherit things like your family, right? But if you don't have a will, what happens in Tennessee is then the state and everyone else will look to a statutorily set way that of inheritance. Like, it lists the first priority spouse and children, and then it goes to siblings and parents and those types of things, right? So if you don't have a will, that statutory construct will be followed for what happens to your things after you pass away. But if you do have a will, you can set out what you want done with your stuff. Like, I have a child, right? I might want all of my things after I pass away to go to my child instead of my spouse. I could do that if I wanted to, right? Through the vehicle of a will. If I don't set it up that way through a will, then according to the statute, the majority of my things would go to my spouse and then to my child. Okay, so you can use a will to kind of set up what you want done. If you want some money to go to a nonprofit or a charity, a will is a way to do that as well. In Tennessee, we have 2 types of wills that are recognized. The first one we have listed is what's called an attested will. And that's what folks tend to think about when they think about a will that comes from an attorney's office, right? It's attested. It means that it's witnessed and a notary has signed off on it, saying that the person who signed this document is indeed the person listed in the document, right? So that's what an attested will is, generally prepared by an attorney, not always, but generally. It follows the statutory constructs for what makes a valid will here in Tennessee, and that's a little much to get into today, but there are certain things that attorneys and lawyers have to include in wills. And then they have to be witnessed, and then they have to be notarized. And you can also do a self-proving affidavit for your witnesses and all those types of things, which means that we don't have to find the witnesses later, right? To prove that they saw you sign this particular will. The other one is what's called a holographic will. And Tennessee does recognize a holographic will. And all that means is someone took a sheet of paper, like I took a sheet of paper, and I just wrote out what I want to happen to my things in my own handwriting, and then I signed and dated it. That is considered a valid will in the state of Tennessee. But it has to be completely in my handwriting if I'm the one executing that will. Okay, there's not really any witness requirements or anything like that, but it has to be completely in my handwriting, signed and dated. Doesn't have to be notarized or anything like that. So questions there about the two different types of wills that are recognized in Tennessee and a little bit about them. I will tell you that it is very important to have a will, as I've mentioned, and then also one thing to consider, and we don't spend a lot of time or actually any time or any slides in this presentation, considering the probate process. Why we have a will is to tell where we want our stuff to go after we can't, we're no longer here. And then keep in mind, if there's real property, say I have a house and I'm going to leave it to my child, that my child would then need to go ahead and go through a probate process or some other statutory process to get that title changed from my name to my child's name. It's really important to consider as well. You really can't do anything about it except having a will, identifying that executor who's going to carry out the wishes as you set forth in the will, and then hoping that everyone, probates it and does everything that they're supposed to do to make sure all of your stuff gets distributed as you desire and the titles on those real properties, those houses, those types of things get changed. There are ways to change the titles on houses and cars and things like that other than probate, but probate is the general way we think about that happening. Okay. Any questions? Let me see. Is anything in the chat? I don't think so. But if you have any questions, like I said, don't hesitate just to go ahead and ask. I'm trying to think of anything else that might be helpful in a will. I always get the question about, is there a difference between a will and a trust? And there indeed is. And what I can tell you about a trust is that generally goes beyond the scope of the representation for either a legal aid or someone like TALS, right? We help folks with very simple, straightforward wills. Maybe they have a house, they have a couple of cars, they have some jewelry maybe they want to leave to someone. But if we start talking about a trust, that is something that we always recommend that folks go see a Tennessee certified elder law attorney who would specialize in setting up a trust. Trusts can be tricky. There are many different ways to set them up. They're very tricky. So we're not going to spend a lot of time talking about them, and just know that it is potentially a vehicle, a way to avoid probate, but everything has to be done precisely as the attorney tells the person. Because if it's not, then you're right back at square one and you're going to have to go through probate anyway. Because things have to be retitled when they go into a trust and those types of things. So just keep that in mind. Again, very useful tools for estate planning, but just have some, there's pros and cons to everything, right? So if someone came to TALS and said, we need a trust, we would be like, that's beyond what we can do. So we're going to give you some names of some elder law attorneys in your area that you could contact. And you could see them about that, but that's a little bit beyond what we do. Another thing to keep in mind with a will, people always ask, can I quit claim deed my house if that's my largest asset to a family member? And you can absolutely do that. Just keep in mind that there are some tax implications to doing that. And that's where we would recommend that you talk to a certified tax professional to see what that might do and how that might impact both the giver and the givee of that gift. And also it can impact eligibility for certain Medicaid. Tennessee long-term care is paid for through Medicaid under what's called TennCare Choices. And they have a 5-year look back period, right? So they will look back for at least 5 years. And I always tell folks, I know the statute says 5 years, but I always say 6, just to be absolutely sure. You know what I'm saying? Depending on when they start counting the dates and the time, just to be sure that that doesn't impact someone's eligibility for Medicare, for Medicaid choices. The reason I say that is because if you have a house in your name, like if I was to apply for choices tomorrow, I own a house, that is an exempted asset that's not counted against me for the purposes of qualifying for choices, right? But if I were to sell that house and liquidate it and put that money in the bank, they would count that income that I have in the bank against me, right? Because to qualify for choices, you have to have very low income and then less than around $2,000 in the bank. So just something to keep in mind. It gets a little complicated, but again, I've worked with folks and talked to folks about this, and I'm always happy to do anything like that. Any questions about wills? All right. So that's what we recommend to dispose of things, right? The next thing we want to talk about is a power of attorney. That's what we use. That is the legal vehicle, the legal document that we use here in the state of Tennessee to say what I want done. It gives someone else the ability to step into my shoes and help me and or make decisions for me, depending on how I set it up, related to either finances or healthcare. Okay, so in Tennessee, we have two powers of attorney, one for finances, and I can set one up today and give my person that I appoint, it's called my attorney in fact, the ability to make financial decisions for me, and I can specify what decisions those might be. I can make that broad, I can make that a little more limited. You can sit down with the attorney and talk through that. And I can make that effective immediately upon signing, or I can make that effective upon some other date, which would be at a date maybe when I became incapacitated and unable to make those decisions for myself, right? That's a little more complicated, but it can still be done. And I also need both of the documents, either the power of attorney for healthcare or the power of attorney finances, to be what's called durable. That means that they extend and they are still valid even though I am incapacitated, right? Even though I can't make my own decisions, my attorney in fact steps in and will make those healthcare and financial decisions on my behalf. Now, folks always ask, is there a possibility of someone taking these documents, particularly the power of attorney for finances, and stealing my money and my things? There is, but I will tell you that in the power of attorney for finances, there is a lot of warnings, and there is a duty on the attorney in fact, a fiduciary duty to act only in the best interest of the principal, and that's the person giving those responsibilities to that attorney in fact. Does that stop all bad actors? No, but I'm just letting you know that breach of that fiduciary duty, inappropriately using that power of attorney document, is a crime. And I have seen district attorneys, particularly recently, go after folks and go after those bad actors who are abusing these powers of attorney documents, right? And of course, of the 100 times that the powers of attorney for finances are issued and the attorneys in fact act properly, 99 times, we will not hear about those 99 times that it works as it's supposed to. We will hear about that one time, right? Which is way more than it should. It should never happen, but unfortunately, humans are humans, right? And it does happen at sometimes that there are bad actors. And though they would abuse that financial power of attorney. I'm not saying it's 1 in 100. That's just an example. It's actually very rare that we heard of people being, theft going on through a power of attorney, but just letting you know it can happen, unfortunately. So that's why we choose those attorneys, in fact, very, very carefully, and spend a lot of time and thought in picking that trusted person that we want to step in and make those decisions on our behalf if needed. Another thing to know is either a power of attorney for healthcare or finances can be revoked at any time. Okay, so if you have an attorney in fact and you decide, you know what, it was a friend and we're just not close anymore and I want to appoint someone else, as long as you still have what's called capacity, and we'll talk about that in just a second, you can revoke those powers of attorney at any time. Okay, so just don't think if you execute these documents that you're stuck with them, right, forever. You can make changes, you can make modifications without any issues. And also just know what we do under the statute, the document with the latest date, so the latest in time, that is the document that is considered the controlling document. Okay. So if someone's looking through a drawer and they find 3 powers of attorney for finances, we're going to look at that one with the latest date, and that's going to be considered the one that is valid and moving forward. Who can execute a power of attorney? Anyone over age 18 who has what's called capacity. So capacity means that as the principal, as the person executing the document, I understand the rights and responsibilities I am giving to my attorney in fact. Okay. If I don't understand that I am giving these rights away as an attorney, I will say that person lacks capacity, lacks the understanding to be able to give those rights away, right? I have to understand what I'm doing and the potential implications to me for that. And how do attorneys determine capacity? There are many different ways. I have conversations with folks, right? And a lot of times when I'm having conversations with them about powers of attorney, I will ask them some questions, and I might come back 5 minutes later and ask them the same questions just to see if the answer is the same. If I have some, some thought that maybe the person doesn't understand or lacks capacity, right? So there are ways that we can figure out if the person does understand what they're doing. There are what are called mini cognitive tests that are done in long-term care facilities that I've seen folks rely on as well. I know one attorney, he's done elder law for many, many years. So he will ask folks the date, the president, and to remember the color red. And then he'll come back 5 minutes later and ask the same questions. What's the date? Who's the president? And what color did I ask you to remember? And that's his way of determining if someone has capacity and do they have some recall and do they remember a conversation that was just had 5 minutes ago. The process is you can draft these on your own. I would not recommend it. There are certain statutory requirements that are required to be in powers of attorney. So I would recommend getting with an attorney, either at Legal Aid or TALS. We're starting to do some of these documents now, and executing them, which means they're printed out and then they're notarized and witnessed. And the types are financial, which controls the finances, and power of attorney for healthcare, which controls the healthcare decisions. We're going to talk about next about an advanced care directive. And folks often ask me, like, what is the difference between a power of attorney for healthcare and an advanced directive? And kind of think about it this way, right? Your advanced directive, you are appointing attorney, in fact, for you to make decisions around end of life care. Whereas a power of attorney for healthcare, the document I'm talking about right now, is just a little broader, right? You could give someone the ability to talk to your doctor, to get your medical records, to do other healthcare related things if you need that assistance. Okay, so I usually get a lot of questions about that. Any questions anyone has at this point? Okay. All right, let's talk about that advanced directives or advanced care plan. It is a document in Tennessee. It replaced what's called a living will. So if you've heard of a living will, it is now known as an advanced care plan or the advanced directive. And it really sets out what I want, my preferences and my desires and my wishes for treatment, for medical care treatment, when I can't actually communicate those wishes to medical care personnel. All right. They're used to tell medical care providers what I want about, really truly about life-sustaining procedures and end-of-life care. Do I want everything, or do I want limited things, or do I want nothing? And we'll pull that document up here in just a second. The most recognized advanced directive or advanced care plan in the state of Tennessee is a form that is put out by the Tennessee Department of Health. It is on the Tennessee Department of Health website. It's one page, front and back, and anyone can execute it with 2 witnesses as long as they have capacity and they have 2 witnesses, one of whom is not related to the individual, to the principal signing the document. It doesn't need to be notarized. It could be notarized if you wanted to, but it is a requirement. And then the individual is good to go. Let's see. I do want to mention that an advanced directive, advanced care plan, is not instructive for emergency medical personnel. Okay, folks always ask me that question about, like, somebody had a heart attack and the ambulance was called and they still did CPR, even though his advanced directive said no CPR. It is because the advanced care plan, the advanced directive, is not instructive for emergency personnel. Emergency personnel will stabilize the patient, move them to a medical care setting, generally a hospital. And then at that point, that treating physician, that emergency physician or hospitalist or whomever is in charge of that individual's care would be the individual who would review the advanced care plan, the advanced directive, and then take appropriate actions based on that document. And you can see here, it's a form which is in substantial compliance with the law, witnessed by 2 adults, or notarized. So you have that option, and you've probably seen them. This is what they look like. This is the very top of that document. I would say and I do get this question a lot too, if you're moved into Tennessee from out of state, the last time I had this question, it was I think it was Ohio or Illinois, so a very close by state. But someone moved to Tennessee from another state and they're like, we have an advanced care directive that's based on the laws of Ohio. Do we need to get another one in Tennessee? And my response to that is always, 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 I would recommend, if you move to Tennessee, to make sure you're executing the advanced care plan that is put out on the form put out by the Department of Health, just because our doctors here in Tennessee, our medical care personnel, are very accustomed to seeing this form, right? In the middle of an emergency, we want to make it as easy on the medical care personnel to see the form and to understand that it is in substantial compliance with the law, which the Tennessee Department of Health form is. If they have to read a form that they're not familiar with and parse through it, they might have a question about whether or not it's compliant with Tennessee law, and they might decide that the best course of action is just to disregard that advanced care plan or that advanced directive, and then to provide all the treatment or no treatment, right? Or just not to abide by that advanced care plan. I've actually seen that happen. So I really, really, really do urge folks, if you're coming in from out of state, just to execute this advanced care plan. It's on the website. It's available 24/7. You can hit print. And you will have it, and it's available to you. And then you can give it to the person that you identify as your healthcare attorney, in fact. Give them a copy, give a copy to your doctor, your normal PCP. And then you could also, what I tell folks is, we don't have a central repository in the state of Tennessee to keep advanced care directives. But I always tell folks, if you can scan it and then email it to yourself, you will always, more than likely have your phone with you, or someone with you will have will have the code to get into your phone. So they will always have a copy of this document available for medical care personnel if it becomes important. Folks always ask what age should they be in order to have this document. I say anyone over the age of 18 really should have an advanced care plan and know and understand what their wishes are for healthcare, and have those set out in writing. When I was at the Commission on Aging and Disability, I had a family actually come down to my office, at 4:30 on Friday, because emergencies always happen, late in the day on a Friday. And they were experiencing an issue because they had a 19-year-old college student who had been in a car accident and didn't have an advanced care plan readily available. So they were just kind of talking with me, and was talking to them about some potential solutions, because the child, was no longer a child. It was a very young adult, but still an adult, and hadn't identified someone to make decisions on their behalf. So there are ways we can go about this. There's an emergency kind of a surrogate form for the emergency personnel. The emergency doctor can be appointed. That all takes time, and it generally has to go through a medical ethics board of review at the hospital. So this is why I always recommend folks, even the youngsters, have an advanced care plan, an advanced directive that's readily available. Folks know about it, and somebody, mom or dad, or they have a copy on their phone, or we can readily access that. So just so the wishes of that individual can be carried out and be implemented. The thing I love about an advanced care plan is that it lets me, as an adult human who has capacity, set out what I want. And unfortunately, I couldn't insert the whole document, but it goes into things like, do I want CPR after I'm stabilized and in the hospital? Do I want a feeding tube? Do I want what's considered life support? I can make those decisions. I can say yes, I can say no, I can say sometimes. It just gives me the ability to make those decisions, and then to trust that those decisions will be carried out when I can no longer, communicate. Any questions about the advanced care plan or that advanced directive? Okay. The reason we recommend an attorney, healthcare power of attorney, And maybe in some ways that advance directive is because if neither of those documents are in place, and there is no one who's been, appointed the attorney in fact through a healthcare power of attorney or an advanced care plan, the only option left is what's called conservatorship. Okay. And conservatorship is a very lengthy process. It is a very lengthy court process where a petition has to be filed. And basically that petition says that I, as the individual, no longer have capacity, can't make my own decisions. Therefore, I need someone to step in and be able to make those decisions for me. And unfortunately, through the conservatorship process, someone else will pick who that attorney in fact is, who will be making those decisions on my behalf. And the court can actually choose that person as well. So it really does remove a lot of the choice from my, my end of life care, and gives that power to the court and other people to make those decisions. Conservatorship really does take all of the rights away from an individual and vests them and gives them to someone else. Again, a conservatorship does have its place and it is a very valuable tool, but it is something that is really sad. And it really is a very lengthy and expensive court process. So just keep that in mind. If someone loses capacity, I've seen family members be appointed because someone had a stroke, right? And was no longer able to, was no longer verbal and also had some cognitive impairment and were no longer able to make their own, financial decisions and healthcare decisions. So it really does have a place. But if there was a durable power of attorney in place, then that family would not have to have gone through the conservatorship process. They would have been able to take that durable power of attorney for healthcare and finances out and been like, here you go. They've already, my loved one has already said if they should become incapacitated, they want me to be their attorney. In fact, here's the legal documents proving that, and they would be able to step in and make those healthcare and financial decisions on behalf of that individual. Also know that there's something in Tennessee called a limited conservatorship for emergency conservatorship for healthcare decisions. That if you're in a hospital and the hospital doesn't think you have capacity and there's no one around else to make decisions for you, the hospital can actually file it and have someone appointed as your conservator to make healthcare decisions on your behalf. So when I say it really does take the ability for folks to make their own choices away, it really, really does. I've seen this happen before, and as recently as about 6 months ago. A hospital in the Nashville area filed an emergency conservatorship for a patient. It started a whole domino effect. His bank account was frozen and all kinds of things that we helped him work with his court-appointed attorney to kind of untangle, but it did cause a lot of upheaval. Folks also ask, going briefly back to that power of attorney for healthcare and finances and advanced care plan, if the attorney, in fact, the person that I pick to make decisions for me has to be a family member, and the answer is no. It could be a friend, it could be anyone that you trust can be appointed as an attorney, in fact, under those documents. Okay. And like I said, conservatorship really does have its place and it's a great tool and I've seen it used very effectively, but it also, has some downsides because it is a court proceeding. It's lengthy, takes around 6 months. It's also expensive. Anytime you get lawyers involved, right? All right. So those are the 3 documents that we recommend for everyone. With our remaining time, I did want to go over just a couple of things and kind of some resources that I recommend to anyone. Scams and frauds, right? I've gotten probably 6 phone calls today that I have not answered because I know it's somebody either telling me that I had jury duty and I didn't show up and I'm going to be arrested, or it's someone telling me that I've won the lottery and I have to send them $100,000, or just keep going on and on and on. There are so many scams and they change every single day. So here are a couple of websites that I have found to be very, very useful over the years that are updated very, very frequently. The first one I list is a national website, Consumer Financial Protection Bureau. I love those guys. They do a really good job about protecting consumers. And they have a frauds and scam website, AARP Tennessee. Our friends over there have a really great scams and fraud section of their website that they update. Agewell Middle Tennessee does as well, and so does the Tennessee Attorney General's office. Anytime a newish kind of scam comes up, one of these guys will make sure that they update that and get that out to everyone as well. And I know AARP does, and so does Agewell Middle Tennessee, does scam and fraud alerts. If something new pops in, they'll send that out to everyone just to make sure everyone's aware. So that's some resources that I definitely recommend. Legal assistance. If you do need some legal help, you can always contact Tennessee Alliance for Legal Services. The website that we point folks to is helpfortn.org. And then the two numbers below, the 844-HELP-FOR-TN, and then the numbers are kind of set out there for you as well. That's our legal helpline. And I am so very sorry if you hear a cat meowing. There is a kitten outside of my door who's trying to come in. So I'm really sorry. He won't come in, but he's trying to. So there's that. The programs that we offer and that we recommend are Help for TN, our website, and we'll talk about that in a second, and then Tennessee Free Legal Answers, and then our helpline. The very first one is 844-HELP-FOR-TN. That is a free statewide legal helpline. We talk to 5,000 to 6,000 Tennesseans every single year, and we provide legal advice over the phone and referrals to low-income Tennesseans. Now, we do not income test anyone. So when you call our helpline, we will ask you your name and we will ask you your county, because we do track folks by county, just so for funding purposes, and we will also ask your age. Those 60 and over, we have 2 attorneys dedicated to that help part of our helpline, that branch of our helpline. And then those under age 60, we have 2 attorneys dedicated to that branch of our helpline. Each of those pairs of attorneys have different expertise that makes them more suited for one helpline versus the other. But it's a toll-free legal helpline. You can call in, you will get our answering service, and our answering service will schedule you for a 30-minute call with one of our attorneys, and our attorney will call you back at that appointed time. The attorneys are on staff at TALS. They are all part-time licensed Tennessee attorneys. One of them used to be a federal court clerk. One was worked as a big law partner in California for 40 years. Another one on our senior helpline was a district long-term care ombudsman and has worked in elder law since the 90s. So we have a vast amount of experience and expertise that these attorneys are willing to share. It is legal advice. So for that 20 to 30 minutes, you do have an attorney who is giving you actual legal advice, not just information. And we talk to anyone. The only caveat there is it has to be a civil legal question. We cannot handle any questions about criminal law. So if someone has a question about a DUI or something like that, we have to refer them to someone else. But anything on the civil side of the house, we answer questions about. Our most common areas of law we question about are housing and family law. But we get questions about expungement and divorce and child custody, and you name the area of law and we get questions about it. Contracts and contractors misbehaving, just whatever you can possibly imagine. So our helpline staff are actually in our office and they talk to me all the time. So they keep me pretty entertained and, up to date with the types of calls we're receiving. So we can kind of keep up with trends and things that are going on. All right. Help for TN, our website. We do recommend folks check that out. On that website, we have lots of resources and blog posts about common legal questions. You can see here, this is just a snapshot of the homepage of the helpfortn.org website. Renters and homeowners, you could just click on that and there's more information and brochures available about renters' rights, what to do, if you have a question as a homeowner, divorce, and also senior resources always stay on our homepage as well. Some of the blogs that we recommend are Protecting Your Home from Repair Scams and Frauds. We have a booklet on renters' rights. We talk about utilities because that's a very common question. And then representing yourself in General Sessions Court. We get lots of questions about how do I represent myself if I'm being sued for eviction or something along those lines. So we have a very detailed brochure on the helpfortn.org website that helps guide folks through that process. Another way that TALS offers legal resources in legal help is through our email-based legal advice, which is called Tennessee Free Legal Answers. And it's just TennesseeFreeLegalAnswers.org, I believe. It's a collaboration between TALS and the Tennessee Bar Association. So folks can go to Tennessee Free Legal Answers, they can type in their legal question, and that question is emailed to a whole host of volunteer attorneys that TALS has across the state. One of the attorneys will review that question and provide written legal advice that they will in turn email back to the questioner. So it's a really good option if someone doesn't want to talk on the phone or call the helpline with a question. You can go on to Tennessee Free Legal Answers and ask your question at 3 o'clock in the morning, right? The helpline's closed at that point in time, but Tennessee Free Legal Answers is open. We do ask a couple of questions on the Tennessee Free Legal Answers because it is a collaboration with the Bar Association, and ask one income question. Folks can look at it and review it and answer as they see fit. We ask, I think if you're 250% or below a federal poverty level is the question that's asked. So that's the question, and then ask your question and check your email. You'll receive an email telling you when to log back on and get the response to your question. So it's a really useful tool that we have found over the years to get that free civil legal help out to folks who might have a barrier to either going to a legal aid because of transportation or may not wish to talk on the phone. A lot of our deaf clients are able to use Tennessee Free Legal Answers very effectively to still get access to legal advice without having to talk to us on the phone. The legal aid organizations are also some resources that I want to leave you guys with as well. And I've listed all 4 of them. So starting at the eastern part of the state, and I noticed we had folks from kind of all over Tennessee on this call. There's Legal Aid of East Tennessee, and it serves about 27 counties in the eastern part of the state. Think of Tennessee in 3 grand regions. It serves those counties way up in upper East Tennessee, bordering on Virginia, all the way down to Chattanooga and Hamilton County. And then Legal Aid Society of Middle Tennessee and the Cumberlands picks up and starts and serves the counties in what we traditionally think of as Middle Tennessee, while taking a few of the counties from East Tennessee, like Blount County and Oak Ridge, and serving those counties as well. That was all as a result of mergers that happened back in 2000. So that was 24 years ago. But folks have long memories and still remember, when there were 8 legal services corporation funded entities in the state of Tennessee. Now there are only 4. West Tennessee Legal Services is the next one, and they serve upper West Tennessee. So if you think of West Tennessee, I know it's 1 grand region, but West Tennessee Legal Services serves all of West Tennessee except for Shelby, Fayette, Lauderdale, and Tipton counties. And those 4 counties, Shelby, Fayette, Lauderdale, and Tipton, are served by an organization called Memphis Area Legal Services. So the state of Tennessee is broken out roughly by grand region, and the legal aids serve those areas. And you do have to contact the legal aid that would provide services in your particular area. But one thing to know about each legal aid is they receive something called Title IIIB funding. And that is funding from the state of Tennessee Commission on Aging and Disability, soon to become the Department of Disability and Aging. And that funding goes through the local area agency on aging, and then it goes directly to the legal aids. And that funding is to provide services for Tennesseans age 60 and over, and it is not income tested, right? So they can provide in-person legal representation to individuals who have questions about housing or divorce, or they can, provide documents or anything that those individuals may need. Now, there's always a much greater demand for the service than the legal aids will have funding, but just know that each of the legal aids do have that particular type of funding. It goes to every legal aid in the state of Tennessee to provide services in most of the counties that they serve. So a couple of little exceptions for Legal Aid of Middle Tennessee and and Legal Aid of East Tennessee as to who serves what. Like the area agency serves Knox County, and Legal Aid of East Tennessee serves all the other counties in East Tennessee. So there's that. All right. Any questions? You guys have been awesome. And I know it's about 6:40, it's almost 6:50 or 7:50 Eastern time. So any questions before I turn this back over to Stephanie?